As promised yesterday, let's talk about strike with more detail about the similarities in DPDP and GDPR. Welcome to my YouTube channel where you daily see new content on data privacy. And as I said, let's get into a bit more details about the similarities that you have in DPDP and GDPR. DPDP, of course, I'm referring to the Indian Data Protection Law that has been passed in August 23, and the rules have been in the market for review. Feedback expected to go back to the government on 18th of February 25, and then let's see how fast the rules can get finalized and implemented. GDPR, the European standard for data protection, right? Why do we need to actually compare them? Why are we as Indians even worried about what GDPR is? That's because GDPR has become a global international standard. There are many countries who follow the norms of GDPR, including the fact that the DPDP Act also has some commonalities with it. Base premise of privacy being the same, there are possibilities of being similar and having commonalities. So that's one part of it. GDPR is already implemented. We should try and learn from the experience that the Europeans have seen while implementing GDPR. And we should also be ready that if in case we are there to expand our business beyond Indian boundaries, then we should know what GDPR is and how it works, right? So let's look at the few similarities first. As I mentioned, the base is the same, right? So the base principles of transparency, that means the purpose and the way the data is being process that includes collection, storage, actual usage, sharing with third parties, and deletion from your own records should be transparent to the data principles. GDPR calls it data subjects, right? So the transparency should be there, the accountability should be there, the data processing agency, which India calls as fiduciaries and significant data fiduciaries, and GDPR calls as data controllers, they should be accountable for the way they are processing the information. There is not supposed to be any loophole that says that this has gone wrong because of that, right? They are answerable if in case a breach happens. The collection and usage of data has to be very, very specific to the purpose, and the amount of data collected should be restricted, right? I've been giving many examples in various videos. For example, again, if we go that to a smaller example where we say that the bank needs to open my bank account, they need my name, my address, my phone number, my Aadhaar card, that is unique identification from the government, and maybe my PAN number. Though for opening a savings account, it is required because it is to be in the record updated. But does the bank manager need to know about my family details? Actually, not until it is timely, right? But from an official point of view, the data that is required is the only data that should be collected, and that's where the two terms work together. Purpose limitation, you collect data to the limited purpose, and data minimization, collect minimum possible data. Don't collect extra. If tomorrow my family's information get leached out of the bank and bank never needed it, what is the fun of that, right? So don't collect what is not required. And lawful processing, both Indian and the European laws say that the processing of information should be lawful. It should be done in public interest. It should not be that it harms the privacy of any of the respective citizens. From data subject and principal rights, we have right to access, correction, erasure, and portability. These are the four rights which are absolutely common between the two jurisdictions or two regulators. The principals or the subjects are allowed to access their data, they are allowed to get it corrected, they are allowed to get it erased. GDPR also has the right to be different from the Indian one, and they are allowed to get data portability. That is, exported their data out of one provider so that as it is, that information being in a computer readable format can be read by another provider and they don't need to share the information again, right? So with respect to data subject or principal rights, these are the commonalities. And last but not the least, the compliance and enforcement similarities. The role of the regulators. There's a data protection board that is getting set up in India, and even in the European Union, each member state has to have their own board who oversees the privacy implementation, who answers, who looks into the complaints, who looks into the overall privacy standard being adopted and passes guidelines accordingly. Breach notification is a mandatory thing both ways. There's a breach, you need to inform the regulators, you need to inform the affected principals or data subjects. There are timeline differences between the two, but then their breach notification as a principle is there for both of them. There are financial penalties in both the cases. In India, it's in absolute rupees, 250 crores, the highest one, and in Europe, it is 2 to 4%, depending on the kind of breach, 2% or 4% of the global turnover of that particular fiduciary or controller in terms of GDPR. And the appointment of DPO. The Indian law says that if you're a significant data fiduciary, you need a in-house India-based DPO. Fine. Otherwise, you can get the DPO job outsourced. The GDPR says if you are doing large-scale processing, then you need an in-house DPO. Significant data fiduciary in India is the organization that handles sensitive personal information at a large scale, right? So they are practically the same things in both the jurisdictions. So that's about some of the key similarities between DPDP Act and GDPR. In the next video, we're going to talk about some of the differences between the two. I hope you like the content of this video. Please press the bell and the like channel and share your feedback in the comment section. Thank you.